focus on the Lagos tenancy law and how the Lagos multi-door courthouse is providing an effective alternative to lengthy court battles through alternative dispute resolution. Joining us is Olubusola, an Assistant Director and Registrar at the Lagos multi-door courthouse, to shed light on how mediation, arbitration and early neutral evaluation help resolve tenancy disputes efficiently. Thank you for coming.
Thank you for having me. Good morning.
So let's begin, with an overview of the Lagos multi-door courthouse and its role in the justice system.
Okay, thank you. The Lagos multi-door courthouse is the first court-connected EDR center in Africa, and it was established in 2002.
Oh, it's the first?
Yes, it's the first in Africa. It was established in 2002. It was a private institution at the time, and after some time it was introduced to the judiciary and brought into the multi-door courthouse system. And what it basically means is that instead of one door that leads to resolution of disputes, why don't you have the traditional court? Excuse me. So why don't we have several doors into which parties can resolve their disputes amicably? So that was why the Lagos multi-door courthouse came into being, and it became court connected. And so that's how we have been operating since 2002. So along the line, we had our laws, 2007 law, which regulates the activities of the multi-door courthouse, even with the judiciary and all that. And the law was repealed and another one came on board in 2015, which is what we use right now. So that's what regulates the activities of the multi-door courthouse right now.
All right, so going down to a business of the day, Lagos tenancy law. Now, this is a topic that concerns everyone in Lagos, either you're a landlord or you're a tenant. So give us a brief overview of the Lagos tenancy law in Lagos.
Okay, the Lagos tenancy law 2011 is actually a legislation that regulates the activities or relationship between the landlord and the tenants. And it's just a way to ensure that both parties, both the landlord and the tenant, have a regulated way of, relating on certain issues. So the Lagos tenancy law has to do with residential premises and commercial premises, but it is limited to it concerns Lagos State, but there are some parts of Lagos State under which this law is not applicable.
The
eyebrow areas like Victoria Island, Ikoyi.
Why is that?
Why?
Yes, because there's a law, because of the high value and commercial value of those areas. Excuse me. So we have another law that regulates that, so that's the rent control and recovery of premises law. Is almost similar to this, just that it's more regulated and it gives them a free will to negotiate on certain things. So, but the Lagos tenancy law is limited. It cuts across apart from these places, and it is not something that is applicable to premises owned by educational institutions or emergency shelters or healthcare facilities. So yes, schools. So it just regulates tenancy relationship within Lagos State, taking out all these spaces that we had mentioned. The Lagos tenancy law also provides for how a tenant, what is the rights and obligations of landlord and tenant. For example, a tenant is expected to make sure that the tenant premises is kept in a tenantable position, is not prone to any abuse or any form of things that was not agreed on at the first instance when they took on the tenancy. It also regulates the rights and obligations of the landlord to ensure that the landlord pays rent and charges as expected from Lagos State. The landlord also is expected to ensure that he makes the environment peaceable and let the tenants have a quiet enjoyment of the premises. The tenancy law also gives us an idea or gives us the period upon which notices can be given. For example, if you want to take over your premises for one or two reasons, there are laws guiding the notice that must be given to a tenant, whether you're a monthly tenant, whether you're a yearly tenant, half-yearly tenant, or quarterly tenant. So it provides all that so that it's a guide. It also allows the court to also refer such cases to dispute resolution centers like the Lagos Multi-Door Courthouse when such issues arise. And that is where my organization comes in, where we have such tenancy cases where the court says, okay, this matter is in court, my landlord has brought me to court, I want this tenant out. Okay, why don't you go to the Lagos Multi-Door Courthouse to resolve these cases? And then we go on and on like that and have resolutions that can be enforceable in courts thereafter. So that's just in brief. Okay,
I've listened to all you've said, and we've also mentioned the traditional court. So why is this mediation usually more suitable for landlord-tenant conflicts?
Yes, it is very suitable because, first and foremost, we understand what mediation is all about. Mediation is a party-driven process, whereby both parties sit over a table. They are the owners of the dispute. They are the owners of the issues that brought them to the mediation table. So when they come on board, come at the mediation table, they discuss the issues with the guide of a mediator, who is a trained personnel who understands the issues that the parties will bring to the table. And at the end of the day, parties own the dispute, they own the process, and they own the outcome of the resolution. So it is something like, unlike in the traditional courts, it is their lawyers that speak for them. But in mediation, the parties have the opportunity to speak directly, even to each other, before a mediator, and then address the issues that may not be addressed in court and take ownership of the dispute and the resolution. So in that way, when both of us are speaking face to face, it is easier for us to understand the underlying issues that may not be brought up in court. But when we have a mediator who is guiding the parties, we're able to understand underlying issues, the interest of the parties, even in that dispute between them. So that is why it is something that we have. In fact, I can say that about 79% of our cases, on tenancy are resolved at the Multi-Door Courthouse. So that's why it is something that is very good for such kind of cases.
Okay, are there other advantages such as timeline and all that, why it's, better than
Yes. Another advantage is that when you come for mediation, when such tenancy cases come, we are able to resolve it sometimes in one session or in two sessions, depending. But mostly because the tenancy case is not, the facts are clear. Parties already know what the issues are, and then you're able to streamline it to what exactly do you want. You want the party out, you want him to pay arrears of rent, you want him to put the place in the tenantable position. So those kind of cases, within one or two sessions, you are able to resolve such tenancy cases and the Multi-Door Courthouse. And then it's also enforceable, because by the time you have you've been able to distill the issues and reduce it into writing, what then happens is that you sign off, and then there's a process for it to be enforced before the court. It's still the courts that enforce terms of settlement, and then it becomes a consent judgment of the court, and then you can have your judgment on the agreement that both parties have agreed on. And if you renege on it, the other party can start the enforcement process and get
can go to the traditional court.
Yes.
Okay.
Right. So it's a two-in-one question. How important is tenancy agreement? How important is tenant rent receipt? What are the consequences? Because I've had cases where people, rent space and they don't get receipts.
Yes.
Especially now that we are doing transfers, nobody. You understand?
So, you just drew my attention to something.
So because especially now that we are doing online transfers and then you don't even see your landlord physically and all that, and most of them don't even have agents that they deal with. So how important are these documents, and then what are the legal consequences of not having them when issues arise?
Yes, thank you for that question. And this is something that a lot of people gloss over, because at the time a tenant is looking for accommodation, is desperate, he just wants to get in, and then 2-3 years down the line, you just realize that you don't have an agreement, you don't have anything that is guiding your relationship with this landlord. And landlord can tomorrow say, we never had an agreement. Although, aside from that, there are some things that the court can look at to say that, okay, but this was the intention of parties when you entered into such agreement. So back to your question, it is very important to have agreements in a tenancy relationship, because it sets out the relationship from day one. You already know, okay, this is the amount I have to pay, this is my obligations as per how I take care of your environment, of the premises. You will be able to know that, okay, I'm paying so amounts extra on the aside from the rent that I paid, service charge or caution fees or all those kind of things that landlord receives, just to show that, okay, when I'm leaving, I can use the amount that you've given me to renovate the house if there's any damage or anything. So it's very clear that the agreement is something that parties, both landlord and tenant, must have. And then, of course, the tenancy law also provides that a receipt must be given that will state the names of the parties. It should state the premises, the relationship and all that, the amount that was taken and all that. So it just helps to avoid any future misunderstandings when it comes to what is expected of a landlord and a tenant in court. So if these matters get to court, there's no agreement, it might be difficult to prove the case of whoever it is that is meant to rely on the agreement. So you hear something like, but we had an agreement, both of us put it in, we said it that you are going to allow me stays for so I'm going to pay this amount. I paid for 1 year, but you said that moving forward I'll be paying this certain amount. So it's not clear. So it will now be your word against mine, and then you now have to prove. You have the onus is on you to prove beyond reasonable doubt that this is exactly what the agreement says in court. So it can tilt in whatever direction, either in your favor or not in court, depending on how good or strong your case is. But in mediation, because in mediation, as much as we like to have all the documents that will guide the mediator to understand what the dispute is about, so it helps the mediator understand what it is, but we don't upon so much on technicalities in mediation, because you just feel that, okay, bring every document you have. Aside from this documentation, what is it that both parties are bringing to the table? What exactly is your interest in this matter? Forget all these agreements and all that. As much as know that it is important, but we need to look beyond the agreement, beyond the papers that you have brought up. What exactly is your underlying interest? Is it that you just want this man to do this and to pay and all that? So that is how mediation takes it over when it comes to agreements and all these legal documents that we rely on. But it's very important to have it for the sake of clarity and to ensure that there are no future disputes over what each party's obligations are.
Okay, every day we hear Lagos residents call out agents. So, is there any law, binding these agents and their fees? When they want to let out a house, the agency fees, we have the legal fees, we have the caution fee. Is this also under the Lagos tenancy law, or is there any law binding the agents?
Okay, under the tenancy law, there is no. I know that for a landlord, you have agents, whoever it is that is assigned to you. You choose to have to represent you. The landlord. Even in an agreement, you see where they say this agreement is between ABC and his agents, his previes, his assigns, and all that. So as long as the landlord has put out this person as the person representing me, so that is. But I think there's I'm not sure of any legislation or anything that says that this is what the agent should take. But I think it's a matter of practice. I may be wrong, but I think it's a matter of practice.
But does the law recognize agents?
Yes, it does. It does recognize agents. Yes.
My next question: how do you handle a case where a tenant, or how can a tenant legally challenge excessive rent increases? Because I've heard cases.
What do you mean by excessive?
Yes, because
what do you mean by excessive?
A story now. COVID, that was 2020. And so a landlord increased the rent that year 100%. And then the tenant was saying, oh, let me still pay the former rent this year. Next year, I will pay the new rent. Besides, it's a 100% increase. And it has not been too long that he increased the rent before that time. So now, a case like that, what should that tenant do? Is that not excessive increase?
Yeah, you go for mediation.
Yes, you can come for mediation.
You go for mediation.
But even the tenancy law provides for that, and then a landlord.
You say a stipulated time that a landlord should increase his rent.
Well, it's not stated in the law, but that still goes back to the agreement. Whatever parties agree, is what should be. But if a tenant feels that a landlord has excessively increased rent, the law allows the tenant to go to court, to challenge it in court. So the court will look at several factors, maybe what goes on in that environment, what charges, what do other landlords, charge in that area, look at some other things to come to a conclusion that, okay, maybe this is excessive or not excessive. And then the judge can also, at the end of the day, decide that, okay, this is the amount that the landlord should charge. So the tenant has the right to approach the court, to challenge such excessive rent.
Okay, like the case she came up with is, what if a party, either the landlord, okay, from her case, it's the landlord. What if the landlord chooses not to come for mediation?
Okay, in mediation, okay, so now there are two things. If it's a court referred, because at multi-door courthouse we have walk-in cases, a landlord or a tenant can decide to walk into the multi-door courthouse to ask that I want this case mediated, or the court itself. The matter can be in court, and the court can decide to refer the case because the tenancy law provides for that, without even recourse to the parties, without their consent. The judge or the magistrate can refer a case. So in that case, if the other party, if it's a court referred matter, let me make distinction.
Okay, court
referred. If it's a court referred matter and the other party does not show up, the landlord does not show up, there's no problem. We'll just simply write a report back to court that a matter was scheduled on so date. The landlord was called upon, maybe by emails, by WhatsApp, by letters, and refused to show up, and give a report to court. So in most cases, what the judges or the magistrates would do is that they will refer, by the time they appear in court, because the landlord has to appear in court, so the judge can refer them back. And if he doesn't come, of course, he can go with sanctions for not appearing. Yes, the judge has the power to give out sanctions in that area. So most times when the judge refers it back, they usually come back. And then, so like they say, you can take a horse to the river, but you cannot force to drink water. So in that case, even if sometimes if the landlord might decide to come, I might decide not to be participatory. Because mediation is participatory. You can tell anything you say, okay, I don't agree. At the end of the day, you don't sign anything. So in that case, you still have to do a report to court, because mediation is party-driven, like I said. Nobody is forcing anybody to resolve. But we just encourage parties to resolve the disputes and let them see the benefits of resolving disputes. So what we do is that, of course, we have seasoned mediators who would help parties see what they are not seeing sometimes and let the decision come from the parties. So if you don't show up, what happens is that we do a report back to court, and then the court will take it off from there. The court can decide to go on into trial or decide to refer it back to the multi-door, as the case may be. But if it's a walk-in matter where you walk in and the other party does not show up, we have judges who are ADR judges. So we'll schedule those parties before ADR judges for them to just give reasons why they refuse to submit. And then the judge will take it from there.
Okay, another question, because these things are real-life issues.
Yes.
So a question again about caretakers now. So you have
the rent. The same ones we call agents.
I don't even know. The rent is 250K, just for example, and then the caretaker comes and adds an extra 250K again. And then people are struggling to pay up this money. So is there a way that their activities can be regulated? It is called agreement and commission. So is there a way that the activities can be regulated?
Okay, when you say caretaker, aside from the agents.
You know, some say they are caretakers, some say they are agents. I don't even know how. I don't know the difference anymore.
Okay, from my experience dealing with such, I think the agents are also the caretakers. Yes, they are the ones the landlord or landlady has chosen, you know, to represent them.
So how do you regulate their own billings, because it's pressing on the neck?
So apart from the agency fees, they are saying that in that case,
commission and some other things.
Okay, because some of that's why we need to you know, be able to see these things from the beginning, and the tenant shouldn't be so desperate to just accept anything that way, because by the time you get into it, it's difficult for you to get out.
Now, people are aware that they should know these things, because again, you said earlier that when someone is looking for a house, there's desperation.
Yes.
So are people aware that there are certain things that should be included in the agreement? There are certain things. What are those things that you should look out for before you sign?
Yes. So in an agreement, of course, before you even, the agency fee and all that may not be in the agreement, and it may be. But of course, it's just a normal practice, a norm that when you want to take on accommodation, you pay agreement fees, you pay agency fees, you pay caution fees, you pay the rent, of course. And of course, you must have receipts for all those things. It should not be the same thing with the rent. That's what the law says. So you have your rent separate, then all those things must be clear. 10 it's usually 10%. 10% you know, so those things must be clear. So if there are extraneous things coming into, you need to question some of these things and say, okay, what exactly is this for? I'm paying this, I'm paying that. What is this for? And sometimes we are not bold enough to confront, you know, some of these landlords or the agents at that time. That's why we just allow anything. By the time you get into it, it's stifling. You really can't get out. So it's important that you must get a lawyer before you get into any agreement. It's very important. The landlord or the tenant must ensure that any agreement that is given to him or her, he must show it to a lawyer. Let the lawyer review the agreement and tell him or her what is not and what should not be accepted. That does not mean that sometimes the landlord may just push it and see whether you take it. And then if you fall for it, then that's it. They don't even read it.
You just sign.
So take it to a lawyer, get a lawyer to review it for you and guide you on what you should sign. It's an agreement. It's not set in stone that you must sign it. You must question some of these things and take it back to the landlord and come to a compromise on what should be in there.
Okay, under the Lagos tenancy law, we've had landlord, of course, landlord-tenant issues. Where a landlord is given 6 months notice, you know, to leave.
A tenant.
Yeah, where a tenant is given 6 months notice to leave and he defaults. Are there other options available for such tenants who have, you know, defaulted? Because after the 6 months and they don't go, what next?
Okay.
Under the tenancy law of Lagos State.
Yes, under the tenancy law of Lagos State, for the 6 months, that means it's a yearly tenant.
Yes,
and and it's been given 6 months notice, which is what the law requires. You know, so in that case, as long as it is lawful, it's a lawful notice. You know, the tenant has to leave. But sometimes you can the tenant.
When you say lawful notice now.
Yes. Because it's a yearly tenant, and the law says that what I just mean is that 6 months.
No matter the reason why the landlord wants.
Yes, the reasons, of course, might be the landlord wants to renovate, or the landlord wants for personal use, or maybe the landlord is not even okay with the way the tenant is using it. As long as you give the tenant lawful notice. Yes. So the landlord has to leave, but the
tenant has to leave.
The tenant has to leave. Beg your pardon. So the tenant who wants to remain, right? Is that what you're saying? That what options does he have?
Yes. What are the enforcement options available? You know,
that's for the landlord.
For the landlord.
Okay. So after 6 months, you know, if the tenant doesn't leave, the law allows him to give him 7 days notice of owner's intention.
Okay, after the 6 months.
To recover possession.
Okay.
So that means he's going to court. He's going to file it in court. So once that happens, because that's what the law says, you give him 7 days notice of owner's intention, and then after that, if it's, of course, the matter is filed in court, a date to be fixed, you know, for hearing of the matter and all that. So, but I have to keep moving to mediation now.
I was going to say, can you go into mediation with this case?
So, but even if you come to mediation, you must have served the necessary notices. Okay. Because that is what the law says. Yes. So you can now come to mediation and say, I've given this person 6 months notice, and this person has not left. I need this person to leave. So what happens is that we would invite both parties, you know, and see, okay, this is what your landlord says, this is what the tenants, and this is what your landlord says. What do you say? So you need to file a response. Let's hear from you. So once you file a response and we understand that, okay, I will leave, let him just give me additional maybe 2 months or 3 months so that I can look for accommodation. And one thing that I have noticed in practice is that once the tenant is giving a notice to quit, maybe 6 months and all that, and says, okay, give me time to look for accommodation, what they will say is that, okay, I will not pay for the rent for that year subsisting. So let me use that money to go and look for accommodation. It is not right. It is only if the landlord allows you. Because some of them claim that, okay, because you have told me to leave, this period that I'm still with, because there's rent to be paid even on that period in which you are still within the premises. So you are asking the landlord that, okay, please, give me extra time to look for accommodation and leave. You're supposed to pay for that time that you are living on the premises. Exactly. Except if the landlord says, okay, but some landlords don't mind. They don't mind. Please, you want 3 months, you want 6 months, sometimes you want a year. Just make sure you put it in writing and let us sign. Because if you don't sign an agreement based on that, you are going back to square one and you have lost a lot of time. You want 1 year, okay, don't pay anything. Just sign that you are going to live on so dates. In fact, that agreement has to be as clear as possible because we are at the Courthouse, where you ensure that your terms of settlement is clear and is not ambiguous. It's not something that the judge will now start after be thinking, okay, what did this person say here? Are you saying this? It has to be very clear with dates, with time, with the amount, if any. So it is always good that it is clear that the landlord allows you not to pay and okay, look for that and do. So in that way, you have your time to look for accommodation, and then you also, landlord also is happy that I know that in 1 year or 6 months, I'll have my accommodation back.
All right, I know that you've mentioned this, but I got the question again. So for emphasis sake, does the tenancy law stipulate a time where it permits the landlord to increase his rent? No, it doesn't. So the landlord can increase his rent.
Yes, at his own discretion. Yes.
Well, no, not as he likes. Like I said, it shouldn't be arbitrary. It shouldn't be an increase. The tenancy law does not state. Okay. It doesn't state that you must not 2 years or 3 years. No. But if the tenant feels that this rent that you are increasing is too much, I can't afford it, then of course you can now have a conversation around that. And then
what if the landlord is just using that rent increase to just push away, which is what they normally do.
Yes.
There's another case. It's real life issues.
Yes.
So this case, the landlord gives the tenant a quick notice, and the time elapsed, and then so she goes to, goes for mediation and all, and then the landlord says, okay, if you're not going to leave, I'm going to increase the rent, and so you're going to pay like a new tenant.
You are renewing the tenancy.
Is that right?
No, it's an agreement. Yeah. As long as both of them agree. Okay. But the person is not paying, Abi. That's why the landlord wants the person out.
No, the person is paying.
Okay.
He just wants her out.
Okay.
And then he says, okay, since you don't want to go, so you're going to pay like you are a new tenant and increase the rent and everything.
But the person has not left. He's still within the premises. Yeah, so so it is still back to what we're saying. Is it something that the tenant is agreeable to?
She didn't have a choice because she didn't have any other place to go to.
So she agreed to the increase?
Yes.
Well, if she agrees to the increase, but I'm sure most people will not want to agree to the increase too. So rather than me, well, it depends on different people. Rather than agreeing to this increase, why don't I look for another accommodation? But meanwhile, you are going to pay more on tenants, on agreements, on this, or get a new place, or you can decide to stick with this and see how it goes.
Okay, just before we go, how can residents have access, or access LMDC services, and what are the steps they should take to file a tenancy dispute?
Yes, so you can walk to our offices. We have our office at Lagos Island, on the island 27-29 King George V Road, Onikon, Lagos. You can just walk in, have a matter, and then we'll give you the requirements. You have to file your statement because we need to know what.
So your office is only on the island?
No, we have on the island. We have in Ikeja, within the ICO premises, or Bakinjobi Way.
Oh, okay.
We have at Korodu High Court, Higher Magistrates Court. Okay. We are there. We are at Ogba, Samuel Ilori Courthouse. We are also there. And then if you don't want to walk into us, you can send a mail to our official mail, info@lagosmultidor.org or registry.lmdc@gmail.com. So once you send a mail that you want to refer a matter, we'll send you the requirements. You can file online as well through those means, and then we'll invite the other party and have a mediation and see how it goes.
Okay.
There.
All right, this mediation, just before I round off, is it free?
Well, we have the free parts and we have the ones that is not free. Okay. We have a special program we hold 3 times a year, which is the Lagos Settlement Week, which is a free program where parties can come in and resolve their disputes. Like I said, the statistics I gave the other time was for the Lagos Settlement Week, about 79% resolution of cases that are real estate cases. So you can do that, but if you walk in on a regular, when we don't have the special services, then you have to pay something.
When do you normally have the special services?
Yes, we have. We usually have in June or July. Just watch out for the flyers and information, and then we have within the first quarter, we have in June, and then we have the last quarter of the year.
All right, it's an interesting conversation and very insightful that we've had talking about Lagos tenancy law. Thank you so much, Olubusola Ojo, Assistant Director, Registrar at the Lagos Multi-Door Courthouse. Thank you for your time.
Thank you very much.
The conversation continues. Stay with us.